Hey everybody, welcome to Hidden Horror. How are you guys doing today? So I'm here now. I want to talk a little bit about Bryan Kohberger's right to appeal. So initially, when we were told about the plea agreement had provisions that were set forth that Bryan Kohberger agreed to that he would not appeal appeal on any issues and just appeal his conviction. However, as I told you in a few videos back, Judge Stephen Hippler said when he was sentencing Bryan Kohberger that he did have a right to appeal and he had 42 days to file a notice of appealing his conviction. And he has 42 days from the date that the judgment is entered, and the judgment was entered on July 23rd, 2025. Seems like a long time ago, but it really is pretty recent, okay? So let's talk a little bit more about it. Let's filter this idea through. So the first thing I want to do, I'm going to bring up a picture of Bryan Kohberger. We're going to be talking about him for a moment. And I always like to have a picture of the person that I'm talking about up. Okay, so that's first. Now, there was in his commitment paperwork on the 5th page this notice that he had a right to appeal. So we're going to go over that. And then in that statement, in that written statement, it also talks about Idaho Rule 35. So I didn't know what Idaho Rule 35 was. So I wanted to read that rule to you and we can just take it for what it is, okay? Um, it's listed on the Hidden Horror Facebook page, or you can type it in and find it for yourself. So, Idaho Criminal Rule 35, it has three parts to it. It's for correcting or reducing a sentence. So, the first part is Part A, it's illegal sentences. And the court may correct a sentence that is illegal from the face of the record at any time. So that's part A. Now we're going to go down to part B. You have sentences imposed in an illegal manner or reduction of sentence. So it says within 120 days of the entry of the judgment imposing sentence or order releasing retained jurisdiction, a motion may be filed to correct a sentence that has been imposed in an illegal manner or to reduce a sentence, and the court may correct or reduce the sentence. The court may also reduce a sentence on revocation of probation or on motion made within 14 days after the filing of the order revoking probation. Motions are considered and determined by the court without additional testimony and without oral argument unless otherwise ordered. A defendant may only file one motion seeking a reduction of sentence. So they will hear that, they will consider that without any testimony or oral argument. Okay, that's part B. And then part C, you have credit for time served. It's a motion to correct a court's computation of credit for time served granted pursuant to Idaho Code Section 18309 or 19 2603 may be made at any time. So the judge is going to refer to this Idaho Criminal Rule 35 and what we're going to read for the notice of appeal. So I wanted you to know that information. You can consider it however you want to, okay? So we're going to take Mr. Kohberger down and we're going to go to the Hidden Horror Facebook page and go over the court's order, okay? So let's go down to that. It's a 5-page document. I'm going to enlarge it here as much as I can. and we can go through. We're not going to read his judgment of conviction. We already know that Mr. Kohberger, he was convicted through a plea agreement, and he pled guilty to all the charges. And within that, he received 4 life sentences, 1 for each victim. I apologize for all of this. I was trying to close my comments out. And Mr. Kohberger also pled guilty to the charge of burglary, and he received a 10-year sentence for the burglary charge. And then he had some restitution entered, and they also said they would have so many days to bring the restitution back up again. Okay, so we're not going to go through the judgment of conviction and his commitment. I pretty much said it to you already, so we don't have to really go over these pages. The page that we're going to go over and review is page 5. This is his notice of appeal. So I'm trying to, my apologies, I'm trying to enlarge it in a way that we can read it, but I'll read it for you, okay? So, pursuant, and this is page 5. Pursuant to the plea agreement entered by this court on July 2nd, 2025, Defendant Bryan C. Kohberger waives all rights to appeal any and all issues in this case and waives the right to file a motion pursuant to Idaho Criminal Rule 35. So we just discussed, my apologies, we just discussed the Idaho Criminal Rule 35, right? We just talked about that and the 3 parts to it. Again, you can have an illegal sentence where you have to correct the record for the illegal sentence. Part B was sentences that are imposed in an illegal manner or reduction of sentence, right? And that is where you're not going to have any oral arguments. You're not going to have any testimony. The court will just consider your request. And then part C was credit for time served, okay? So that's what Criminal Rule 35 is, okay? Let's continue. Nonetheless, should defendant elect to file a notice of appeal, it must be filed within 42 days from the entry of this judgment. So we see here the date for the entry of the judgment is July 23rd, 2025. So it appears that Bryan Kohberger has 42 days after this date, July 23rd. So that will push him into the early part of September, almost mid-September, if he chooses to file a notice that he's going to appeal. Now let's continue in the next paragraph. It further says, you are further notified that you have the right to be represented by an attorney in any appeal, that if you cannot afford to retain an attorney, one may be appointed at public expense. Further, if you are a needy person, the cost of the appeal may be paid for by the state of Idaho. And if you have questions about your appeal rights, you should consult your present lawyer. So I just wanted you guys to know that, because for me, when Judge Hippler, when he said that, I was a little surprised, because he had already agreed in the plea agreement that he was not allowed to appeal, but apparently he can appeal this, and he has to do it within the time frame of 42 days. So I just wanted to share that information with you. I want to also share a very short video clip. So we'll add this to the screen. It's less than 1 minute, and then we'll wrap it up. This video is provided by Crim2 News. It's titled Criminal Law Expert Discusses the Right to Appeal and How It Applies to the Kohberger Case. Okay, so let's enlarge this and listen.
By signing this plea agreement, the now convicted killer also gives up his right to appeal, except during a hearing last week, Judge Stephen Hippler made mention of a U.S. Supreme Court case, Garza v. Idaho, that he says means the defendant can still appeal. In that case, a convicted man in Idaho successfully argued his attorneys were ineffective after they did not file his appeal when he asked. So we asked a criminal law expert, University of Idaho professor Samuel Newton, what this could mean for Kohberger's case.
Just because he signed an appeal waiver doesn't mean he can't technically appeal, but it's going to substantially limit his right to appeal. The best kind of appeal he would still have would be my attorneys lied to me, which is what Garza says. I was pressured behind the scenes to do things that I didn't agree with.
But Newton stresses Kohberger's chance to appeal is significantly reduced, and it's unlikely to happen at all.
Okay. So I just wanted to share that information with you that Bryan Kohberger, he does seem to have this right to appeal. He has 42 days to do it from the date July 23rd, 2025. Thank you for spending this time with me. I really, really appreciate it. I want you to stay safe, stay smart, stay savvy, be well, all my friends. Bye, everybody.